One of the pitfalls of recording a legal podcast is that the law is constantly changing, and this episode was recorded before the publication of Mr. Justice Cusworth's decisions in the cases of LP and MP and Lowe Groniger. Welcome to Control and the Law, the podcast about coercive control and stalking from a legal perspective. Today, we are discussing whether domestic abuse should be taken into account in financial remedy proceedings. I'm Sarah Ellis, barrister, and I'm joined by Samantha Hillas, King's Counsel from St John's Buildings Chambers in Manchester. Sam specialises in financial remedy work and was recently elected leader of the Northern Circuit. My second guest is Olivia Piercy, solicitor and partner at Hunter's Law in London. Olivia is recognised for her expertise in domestic abuse and sits on Resolution's Domestic Abuse Committee and is co-chair of its Economic Abuse Working Party. My third guest is Anita Mehta, barrister of 4 Paper Buildings Chambers in London, and Anita specialises in financial remedy and private law work and is the co-host of Resolution's podcast, Talking Family Law. And very recently, Anita did a joint podcast with Sir Nicholas Mostyn and Baroness Helena Kennedy on their Law and Disorder podcast about this very topic. So thank you all for coming on the podcast and agreeing to discuss this fascinating issue. And broadly, we're talking about conduct in financial remedy proceedings and specifically domestic abuse as an issue of conduct. And Sam, can you explain how conduct can be taken into account in financial remedy proceedings?
Where practitioners often start is a 2021 case that was decided by Sir Nicholas Mostyn called OG and AG. That set out 4 fairly distinct categories of conduct which may be considered within financial remedy proceedings. And when we consider those categories, which I'll talk about in a moment, practitioners often fall into the error of thinking that only one of those categories relates to domestic abuse or coercive control. So the 4 categories, and I'll deal with them in reverse order. First of all, we've got the category of drawing of adverse inferences by the court. So, for example, when a party fails to give full and frank disclosure, and what the court has to do is, when it's computing the assets, is make an adverse inference about what those assets might be because there hasn't been full and frank disclosure by one party. We've then got the issue of litigation misconduct, where one party acts deplorably during the course of the litigation to make the whole process very difficult for the other party, difficult for the court to deal with. And where that's proven in cases that will often sound in costs. So it's not a distribution issue, it's more of a cost issue or potentially a computation issue. We've then got the issue of add-backs, which is where one party has wantonly or recklessly during the course of proceedings or post-separation dissipated assets which would otherwise have been on the asset schedule. And so we call it add back because the court notionally adds those back. But then we've got personal misconduct, which is the 4th category. And what he said is that that's the kind of gross and obvious personal misconduct meted out by one party against another, normally, but not necessarily during the course of the marriage. And he reminded us all that the House of Lords case of Miller and Macfarlane from 2006 confirmed that that kind of conduct can only be taken into account in very rare circumstances. And that's really, as I say, the only category which relates to distribution, or if you like, it reflects what he referred to later on in the judgment in a slightly different context, a moral judicial condemnation. And so what often happens is that practitioners fall into the error of thinking that when we're looking at domestic abuse and coercive control behaviour, we're only really dealing with that category about personal misconduct. But to us, who are really immersed in this issue, and to a lot of practitioners who are engaged in the issue, it's clear that if you have an abusive relationship, it often manifests itself in each of those areas. A party who is guilty of abusive behaviour will act deplorably during the course of proceedings and make it very, very difficult. They will hide assets and fail to disclose assets. They will wantonly and recklessly dissipate assets by trying to park them elsewhere. Or it may be they just think, well, if she's going to get half of it, I'm going to make sure I spend a load of it before it's distributed. And so we have to be alive to all of the different categories of conduct when we are dealing with financial remedy cases. But of course, where we really focus and where the authorities have focused in this area is the personal misconduct. And there is a body of authority, which I know Anita's going to talk about now in terms of how that's developed and where we are.
I will cover a little bit of the history, but I'm going to say for your listeners that if they want the detail on the history, they should go to the Law and Disorder podcast and listen to it from Sir Nicholas Mostyn. So in a slightly shortened form, judicial divorce has been available in this country since 1857. And since the law was first introduced, the court always took conduct into account. And in 1970, statutory reform meant that the court's task was to place the parties, so far as it is practicable, and having regard to their conduct just to do so, in the financial position in which they would have been if the marriage had not broken down and each had properly discharged his or her financial obligations and responsibilities towards the other. Now, how to interpret that test reached the Court of Appeal in 1972 in the case of Vactel. And I have been talking on this subject for 3 years, routinely, recorded and live. And it wasn't until after the Law and Disorder podcast that I got a message from someone who said, by the way, you pronounced that name wrong and you've been anglicising it. So for years I have been saying Vactel, but I should be saying Vactel, I think. But in any event, in that case, it reached the Court of Appeal. And the reason is this: at first instance, the judge had decided both parties were equally to blame for the marriage. And then he went on to decide the finances, and he made an order for maintenance as well as giving the wife half the house. And the husband appealed. He went to the Court of Appeal. Bear in mind, this was the 70s. And he said, why should this woman, who is blameworthy, she's contributed to the breakdown of our marriage, receive the same as effectively an innocent wife who hasn't contributed? And when it reached the Court of Appeal, and I had this discussion with Sir Nicholas, I was saying, look, I think the Court of Appeal were being progressive at that moment when they were saying conduct shouldn't be taken into account unless it's gross or obvious, because what they were dealing with is this question of should we assess the blame of women. But they were only progressive to a certain amount, because actually, although they were still saying, look, it should only be gross and obvious, they're still talking really about the woman who's left the marriage or contributed to the breakdown of the marriage. So what's happened more recently? Well, we've heard from Sam about OG and AG. ACs have reached the High Court in 2023 and in 2024. These are decisions of Mr. Justice Peel, who's now our lead judge of the Financial Remedy Court. And he was asked in both of those cases to look at how conduct is dealt with. And in the case of Svetskov and Kairova, what he decided is that if a party is asserting conduct, A, they need to be able to prove it. Well, of course, we all know that. The facts need to establish the exceptional level, which we have in the statute. And thirdly, that there needs to be an identifiable, even if it's not always measurable, negative financial impact upon which the conduct is based on. So effectively, you have to be able to prove something has happened, and this is the financial consequences of that. The same question effectively reached him again in 2024 in the case of N&J. And in that case, I think you can say he just slightly softened the requirement for a financial consequence, where he accepted that the statute does not require a financial consequence. And he says it's therefore wise not to rule out completely the theoretical possibility of conduct being taken into account absent a financial impact. But nevertheless, as the review of the authorities above suggests, such cases will be vanishingly rare.
For my part, that's not what the statute is intended to do. And so in terms of linking the statute to the authorities, I know that we all share this view, it is that when the statute talks about conduct which is inequitable to disregard, for the authorities then to say that conduct has to be exceptional, or that conduct has to be gross and obvious is an impermissible gloss, which doesn't exist in the statute.
So, Olivia, do you want to tell us what the research is telling us about the outcomes for victims of coercive control in the financial remedy courts?
Yes, absolutely. I would say on that exceptional point, I think that is one of the issues with domestic abuse is that it's not exceptional, it's commonplace. And that's why one of the reasons why the court doesn't want to deal with it. But the fact that it's so prevalent is not a reason to disregard it. So in terms of the research, there's been huge developments over the last 5 years, which was really triggered by the first ever domestic abuse definition in the Domestic Abuse Act 2021, which crucially included a definition of economic abuse and economic abuse as part of the definition of domestic abuse. That hasn't led to any other legal or procedural changes in the family court, but there's a growing body of research, which is, I hope, kind of pushing lawmakers in that direction. So between 2023 and 2025, we've got the Fair Shares research, which was published in 3 reports by Bristol University. And that's groundbreaking research surveying 2,400 people who divorced in the last 5 years. And the key findings in relation to domestic abuse include domestic abuse, including economic abuse, is prevalent among divorcing couples. Survivors tend to start the process in a financially more vulnerable position. 5 years after divorce, female domestic abuse survivors are financially worse off than other women divorcees. They have less capital, lower income, and greater financial insecurity. Abuse survivors have to spend more money on mediation and legal costs, but are less likely to be able to resolve their cases in mediation. They either settle early on bad terms, or they have to go all the way to a contested final hearing. And domestic abuse survivors are routinely walking away without pension sharing orders, facing pension poverty in later life. And so that's been hugely impactful. And I think it really does fly in the face of this idea that you have to prove a financial consequence to conduct, because we know now from this research and so much other research, there is always going to be a financial consequence to domestic abuse, but it's just really unlikely that a victim or survivor will be able to prove or quantify that financial impact at the point of separation, because so much of that's going to happen in the future. So in October 2024, Resolution published its report on domestic abuse in financial remedies, and that's something that Anita and Sam and I led on. This was research that surveyed over 500 family justice professionals to gather their views on the interplay between domestic abuse and the financial remedy process. So the key findings from that report are 90% of the respondents said that legal aid and legal fees funding is not sufficiently accessible to domestic abuse survivors in these cases, and perpetrators are taking advantage of delays in the court system to perpetrate economic abuse, and domestic abuse survivors are severely disadvantaged by not having access to legal fees funding. And the resolution report recommended a raft of proposals to prevent perpetrators from using the financial remedy process as a way of continuing to perpetrate abuse and to achieve unfair outcomes.
So to summarise then, there are evidence-based conclusions as to domestic abuse victims are financially disadvantaged in a whole variety of ways. Anita, in the Law and Disorder podcast, you were talking about a threshold, and I think we agree the threshold is too high, that it shouldn't be exceptional. And it's not just about exceptionality, it's also then it has to be proportionate, and PLJ makes it very clear that it's going to be rare that it will be proportionate to argue these things, and yet it's quite proportionate to have arguments about all sorts of other issues within financial remedy proceedings, but not about domestic abuse and the impact of that. So we need to talk about threshold and where the threshold should lie, because there has to be some sort of threshold. There is then this issue about the victim having to then demonstrate a direct financial consequence of the domestic abuse, which I think we would all say there should be a presumption of that, because it's, if you understand coercive control and domestic abuse, it's inevitable that there will be some kind of direct financial consequence. So let's talk about threshold.
Previously, we have suggested that the Domestic Abuse Act provides a very clear threshold. There is a statutory definition. And I think you will find, and you can take this from the Law Commission report, that even charities and groups that are put forward representing male interests accept that if there is a criminal conviction, that should be taken into account. And at the moment, you can have convictions for ABH and coercive control, and that's still not sufficient. So I would say everyone would accept that the criminal law draws a line. There is then a question as to does there need to be the actual conviction. I would say you can't rely on the criminal justice system, because who is to say that the criminal justice system will have completed it before the financial remedy? So I say that gives you a threshold and an easy definition, and that makes the court consistent, whichever court you are in. I don't think you can rely on the Children Act findings either, because they won't necessarily have happened. But again, if you have in the same case in respect to the children, and maybe somebody is found not to be suitable to have contact with their children, I would say that is probably indicative of domestic abuse that is inequitable.
The criminal court uses a completely different burden of proof. It would be inappropriate to rely on criminal convictions. We would never do that in a children case. And, we talk about assessing domestic abuse and financial remedies as if the court just doesn't know how to deal with that. Of course it does. The court deals with domestic abuse and makes findings of domestic abuse and assesses a sensible level, an appropriate, fair, safe level and threshold for domestic abuse in private and public law children cases day in, day out. We are fully equipped to deal with domestic abuse and financial remedy cases without having to rely on the criminal court to help us.
And Sam, where do you think the threshold should be?
Well, in my view, we've got the threshold. The statute sets it out. It's conduct which it's inequitable to disregard. And I agree with both Liv and Anita that when we have a statutory definition of what domestic abuse is, because we've got an Act of Parliament which says this is what domestic abuse is, if that is proven in a case, either because you have already a criminal conviction under the Domestic Abuse Act, or you have a finding in other family proceedings which says that one party has been abusive of the other, or if findings are made within the financial remedy proceedings that there has been conduct by one party against the other which would meet the criminal definition of domestic abuse, then you've got it. That is inequitable to disregard. And if that means that has to reflect some kind of moral judicial condemnation, to use the words of Mr. Justice Mostyn in OG and AG, then so be it.
We've got this issue about proportionality, which PLJ refers to in N and J, and about how most cases it's going to be disproportionate because it will make proceedings go on for longer, it will cost more money, it will make settlement less likely, which you can say about pretty much most issues in financial remedy proceedings. You can make that point about, is it a gift, is it a loan, or dissipation of assets, all of those things. So do any of you have a particular comment about this proportionality obstacle that's also been placed in the way of victims?
Yeah, I think for my part, I'm going to say I think there are 2 points I can make. One is picking up on what you've just said, Sarah, that the court permits all the time parties to run arguments which at a really early stage of the proceedings are not going to go anywhere. And I'm thinking in particular matrimonialisation, which post-Standish is the hot topic. You will have parties running matrimonialisation or non-matrimonial assets argument, even though it's not going to be taken into account by the court. But we don't stop those parties running it. It's up to them. If they want to run those arguments, they run those arguments. And my other point is that this fear that if there has to be a finding of fact in every case before the court will take it into account, that it would then put the financial remedy court in the same position as the private law children court. Every case has got a finding of fact, there's backlogs, things take a long time, etc. I'm not sure is right, because if we have a decision from the High Court or the Court of Appeal which says if we run these cases and we make a finding that there has been domestic abuse or coercive control, we are going to reflect it in the outcome. And it may mean, instead of it being 50-50, it's 55-45. If that's the decision, the parties know themselves whether or not that has happened. So then they take the risk or they don't take the risk. If we know that is the law and that's how the court's going to treat it, then if you know you are an abuser, or if you know you have been abused, that will affect the way in which you view the litigation risk, and it'll affect the way you run the case.
I agree with everything Sam has said. I would also say that there is an increasing propensity to allow arguments about matrimonialization and contributions. Look at the case of Standish. These are arguments run usually to reduce the wife's share. And I think we need to be honest about the fact that we're allowing those arguments to be run, but we're not allowing anyone to talk about domestic abuse, which everybody knows disproportionately affects women. And there is a gendered angle to this whole issue, which can't be ignored.
I'm going to move this on to talk about direct financial consequences now. And Anita, you had a fascinating discussion in the Law and Disorder podcast about that, about really the difficulties of quantifying what that financial disadvantage might be. And it was, I think Sir Nicholas Mostyn talked about personal injury and how there's a moment in time where there's an injury that's sustained and all the losses flow from that time, and it's easy to quantify, and how difficult it is in cases of domestic abuse or coercive control. And I would disagree with that, because my view in terms of coercive control is that from the outset of the relationship, it's coercively controlling. You don't need a point in time. This person is a controlling person when they go into the relationship. And if you're familiar with Jane Monckton Smith's homicide timeline, the history of the controlling person, they have a worldview, and that is that they have a right to control their partner and their children. And so we don't need to go down this sort of convoluted exercise of at what point did the harm happen. But if we just talk about direct financial consequences, which puts yet another obstacle in the way of victims being compensated for this within financial remedy proceedings. Anita, do you want to come in on this?
So what I say about financial consequences is this: that requirement is almost impossible to prove unless you are looking at financial abuse. Okay, so if the money has been taken out of the asset pot, that's a bit easier, isn't it? The money's come out of the pot, 100 grand's come out of the pot, add the 100 grand back in. Or maybe you think maybe there's a bit more than the 100 grand, you add in maybe a bit more than the 100 grand. But that's where it comes from, is the ability to make sense. Now, in terms of other forms of abuse, it just becomes much more nebulous. And that's the issue, isn't it? If someone has had their earning capacity taken away, well, that's fine if they were a lawyer and they were earning X, and then they can't be a lawyer and now they can't earn it, then you can assess it and you can say that's compensation and here we go, here's your figure. The problem is, what about the victim who continues to work? Who's the person who's holding it all together? Because they could be financially abused, horrifically personally abused, and yet you can't find an obvious financial consequence there. So they're completely blocked out of having this conduct taken into account. Or what about the person where the picture's mixed? Maybe they've got mental health issues before. Maybe they have other things going on in their life. And it's very hard then to separate out and say, well, X is caused by the abuse, but Y is caused by your history. You know, we just can't do it. I would suggest putting in that requirement effectively says domestic abuse in all of its messy, insidious, creeping ways just can't get taken forward. I heard David Challen speak last night about growing up in a household of coercive control, and the most serious coercive control, obviously. And the word he used was, it was like living in a fog. That's how he described it. But it is so impossible to prove the fog, let alone what are the financial consequences that you can box up in a neat way and prove to the judge as a result of that fog.
I think what I would say is, if the court says, well, you've got to have a financial consequence, the response could be, well, here you go. I will give you all of these reports which make it absolutely clear, if it wasn't already clear from a logical point of view, that, and I agree with Liv, this is a very gendered issue, so I am going to be gendered about it. It is obvious that women who are in an abusive relationship for years and years and who are coercively controlled by their husbands will be psychologically damaged by it. That is trauma. And it may very well be that at the point of separation, it is obvious how that trauma has affected that woman, and she may be able to get reports about it. But it may not be, because what we also know, and all the research tells us, is that a lot of women don't recognise it until it's over. And that's picking up on what Anita's just said. And so if we accept as a matter of fact that if a woman has been in a long-standing abusive and coercively controlling relationship, there will be a psychological impact on her. If we then say we can accept as a matter of fact that the way in which that psychological impact will manifest itself is in less likely to have a well-paid job, less likely to go for promotions, have a smaller social circle, everything that flows from it. If we can take that as read, and I think we can take it as read because we've got so many reports which say this is the impact of domestic abuse and coercive control on a party who's suffered it, we've ticked the box. Because what Mr. Justice Peel said is there has to be a financial consequence. It may not be easily measurable. Aren't we able to say, well, we know that there will be a financial consequence. We can't really measure it because its impact will play out over the rest of that woman's life. And if we go back to what the House of Lords said in Miller and McFarlane, Baroness Hale in particular, that the ultimate objective of financial remedy proceedings is to give each party an equal start on the road to independent living, well, we would not be achieving it by simply dividing the assets equally when you have one party who is in a much stronger psychological position and could just carry on moving forward, and you have another party who has suffered trauma, will be psychologically affected by that trauma, and that psychological trauma and the impact of it will continue to affect them for the rest of their life in all sorts of ways, including financially. It's about, and I think you and I have talked about this before, Sarah, it's about equity, not equality. That's what Section 25(2)(g) says. Conduct which it's inequitable to disregard.
There are going to be consequences from being in an abusive relationship that are just unquantifiable. So, for instance, that resistance to forming future intimate personal relationships, that inability to trust new partners. And I think one thing that concerns me greatly is sexual coercion, because I think many victims won't speak about the sexual coercion that goes on in a relationship. And it's going to be there in the vast majority of cases, because to imagine that somebody is coercively controlling, and they're coercively controlling about who you can talk to and what you can wear and what job you can do and all of these things. But when you get in the bedroom, they're not coercively controlling, is quite frankly naive. There ought to be, I'm going to put this out there ought to be a presumption. I think we probably all agree this, that there is financial consequences from being in a coercively controlling relationship. There ought to be that presumption. Maybe it can be a rebuttable presumption, but that should be, in effect, the starting point.
And I think a case that really brought it home to us was a case a few years ago it wasn't a High Court case. It was dealt with by a Deputy District Judge, a case called KA and LE, where there had been findings of really serious domestic abuse and coercively controlling behaviour. But the wife who'd suffered it had managed to keep a well-paid job, had managed to pay the mortgage, had basically managed to hold it together. The judge said, well, there's been no financial consequence because, look, she's doing all right. Whereas, the husband had acted appallingly in all of the ways that we've mentioned in terms of conduct. He'd given up a well-paid job, said he couldn't work, minimised his assets. And the conclusion in that case was 50-50, which completely failed to take into account that woman has been affected. We thought that decision did not accurately reflect the fact that woman, one, needed compensating for what she had suffered and what the court had already found to have suffered. It wasn't just allegations, there'd been proven findings. But two, it completely failed to reflect the ongoing effect on her for the rest of her life of that psychological abuse. You mentioned inability to trust and form new relationships. That sounds really simple, but let's think about that. If you are in a relationship, you are going to have a 2-income household and your expenses are going to be shared. You are going to be in a better financial position than somebody who's living as a single mother with 3 children. And so if one of the impacts of the abuse is that you will find it difficult to form new relationships, you are going to be financially disadvantaged compared to the abuser who's going to go and find another woman to abuse.
Okay, so we agree there needs to be a change. So the question is, how can we engender this change? So I think there is going to be disagreement at this point. Does it require statutory reform? Can it be done within the existing legal framework?
So there's the two sort of different strands to this topic is protecting survivors of abuse from further abuse through the process. And I think if we did have a financial remedies equivalent of Practice Direction 12J, which we have in private law children cases, that would help to make the process safer and would achieve fairer outcomes. But that's sort of separate from the substantive law that we've been talking about, of looking at whether we should be awarding survivors of abuse a greater settlement as a result of the abuse that they've experienced.
But from my perspective, I think it's clear from everything I've said is that I think we have the statute which says if there is conduct which it's inequitable to disregard, it's got to be taken into account in the distribution of the assets at the end of the marriage. My view is we need a brave judge to make a decision at a high court level, or we need a brave litigant who will take it further than the high court to the Court of Appeal to say that the high court is wrong and that it has to be adequately reflected, and we have the legislative tools to do that. So that's where I would almost disagree with Liv.
One of the concerns I have in general about coercive control is the lack of consequences for controlling people. If you think about it, they just get away with so much. We will be talking in a minute about the post-separation abuse, the litigation conduct. We're talking about dissipation of assets and how high, again, the threshold is for add backs. So we're talking about things like post-separation abuse, false allegations to social services, to DWP, to the police, all of these tactics of control that occur during post-separation and also within the relationship. We're talking about a conviction rate of around 2% for domestic abuse, 1.3% for coercive control. There are effectively no consequences for behaving like this. And that seems to me to be fundamentally unfair for victims. You know, we have got a government that says it's going to cut VAWD by 50% within a decade. Or why don't you start with the family court? Why don't you start with the financial remedy court and change the legislation to make that happen? So, does anyone want to come up on that?
My view is that, Sam is right, we shouldn't need statutory reform. It's ridiculous that we are campaigning for statutory reform when the statute already directs judges to consider conduct which would be inequitable to disregard. So it's ridiculous that we're having to campaign to reassert the law that already exists, essentially. But I don't have any faith in the judiciary that they're going to course correct at this point. They don't want to change their approach. They've made that very clear. And in October, Mr. Justice Peel, the head of our financial remedy court, recognised in a conference that Anita was speaking at in front of hundreds of family lawyers, he recognised that the issue of conduct needs further consideration, but suggested that it was a job for the Supreme Court or ideally for Parliament. My clients and survivors, they don't have the resources or the fight in them to take a financial remedy case all the way up to the Supreme Court, and we can't rely on them to do that. So I do think Parliament has to fix this. And I think that it would be helpful to have domestic abuse specifically inserted into Section 25, that judges are directed to consider that separate from conduct. We're not talking about immoral conduct, we're talking about unlawful conduct. So let's be clear.
The Financial Remedy Court needs to work out where it fits in the court system, doesn't it? Because when you go in front of the court for your children case, or if you go in front of your injunction, the court's task there is about making people safer, isn't it? It's about assessing risk and ensuring that the victim or the children who are in themselves victims are safer. And the Financial Remedy Court has followed the line that it is not there as a arm of the law that is to make people safer. And there's a question about that in terms of where we are now as a society and where we are now in terms of what the government is saying. But that's the reality. It's not a function of the law that is there to compensate people at the moment. Now, there's that tension, isn't there, between that being one of the strands we consider, but not when it comes to abuse. And again, we might agree with ourselves and say it doesn't seem right that the Financial Remedy Court doesn't uphold the rule of law in that way, but that's where it is. And I think if you go to most financial or a lot of financial remedy practitioners, they would say, well, we're not a function of safety, are we? We're not about making people safer as they go forward in their independence. I mean, isn't that part of the point here?
But it's about fairness. The whole purpose of the Financial Remedy Court is a judge in the Financial Remedy Court is to make a fair order, and to ignore what is criminalised behaviour that is endemic, that it has horrendous consequences for victims, and to not in any way mark that in the distribution of those financial assets has to be, in my view, inherently unfair. Because we mark other sorts of behaviour within financial remedy. We mark the dissipation of assets. We mark, various other things. Why not domestic abuse? And it is a policy decision. It's about backlog. It's about time taken to finalise cases and all the rest of it. I get that, but it still doesn't mean that it's fair for victims. And there is this fundamental unfairness that I think we're all seeing increasingly because it's so prevalent. And people now are recognising they're victims of domestic abuse, coercive control. They're raising these issues and they're not getting anywhere. I mean, as soon as you raise the issue of domestic abuse as conduct within financial remedy proceedings, you're met either with silence or with counter allegations and certainly threats around costs, aren't you?
We're talking theoretically, we're talking about the law, we're talking about how it's applied by the High Court. Let's talk about the cases that we deal with at the coalface. And you're right, every time, if you're in a case and you raise the issue of conduct, you get an eye roll and you get a threat of costs, which is, if you run this, we are going to be claiming costs against you. You're going to lose. It's going to cost you a load of money. And when you've got a client who's a victim of domestic abuse, so has already been traumatized, and you say to them, if you want to run this, I'll back you, I'll support you, I'll run it for you, I will be your advocate, but let me tell you now, it'll be a really grueling and expensive process. They say, no, thanks. What's he offering? Is he offering 30%? I'll take it. Yeah, I know that I should get 50%. I don't want to go through that. And to pick up on something else you've said, Sarah, they get away with it. So what they think is, if I'm in a toe-to-toe fight with this fella, he's going to be believed because everybody always believes him. He's charming. And they say that to you, don't they? The clients say that to you. He won't come across like I'm telling you. He's really charming. Everybody loves him. He's the fella who goes down the pub, who buys everybody a pint. Everybody thinks he's a great bloke. And they really worry that they're not going to get home on these things. But then there is another aspect of it, which is that when we are dealing with these cases that have dissipation of assets, lack of full and frank disclosure, a deplorable attitude to the litigation, not filing any of the documents on time, not providing what they need to provide, which means that the lawyers acting for the victim has to incur twice as much in cost because they're constantly chasing. And there are no consequences for that kind of conduct until you get all the way to the end. And you're never going to get all the way to the end because your client's going to have given up by then. It's not just a double squeeze, it's a triple squeeze. And when you take on these cases, and I've just taken on one now, as an advocate, you know that you're going to be in it for the long haul because it's going to take a long time. They are really hard work because when you are trying to unpick the financial manipulation of the abuser, it's not easy. It takes a long time. You have to keep going back for disclosure. I mean, I once had a case where we had to apply for something like 39 third-party disclosure orders. So, we've got the starting point of, we know the judges are against us. We've got the starting point of the clients themselves may not have the fight in them for this. And then we've got all those procedural difficulties. It's going to be hard work. You might not get paid for it. And that's why we're in the position we're in.
Does anyone want to come in about your experiences of getting adverse costs against controlling people in these cases? Are you finding it difficult? Are you finding a judicial fair wind? What's going on?
I'll tell you what happens is that inevitably, as Sam said, if you are acting for the victim survivor, your costs are higher. So how it comes in is the other side saying, you have a look at her costs. She's spent a third more than me. She's spent a half more than me, whatever it is. That's how it comes in. And you're saying, no, you have inflamed our costs. But it comes up as they are coming after you for being all the things we have described. That's what kicks off that argument. It's back to who's one step in front, because then the judges think, hang on, I've got one side saying, they should be responsible. The other side, it's bilateral cost applications, which is a very effective defence.
And the problem is that by the time you get to the final hearing and you're looking at costs, and the wife or the victim survivor has got substantially higher costs, of course, nobody has been allowed to talk about the domestic abuse at any point during the case. So when the judge is looking at the costs, they don't see that within the context of a domestic abuse dynamic and everything that has meant for the proceedings. They just go, wife's massively overspent. Why have her lawyers allowed her to do that? She needs to be penalised.
And then how it all started with the absolutely egregious transfers of the assets out to other family members and things like that. And all of those points of add back that obviously looked egregious 3 years ago when you started the proceedings have suddenly paled in comparison to the costs that have been accrued. And so the judge, and I'm not criticising the judge for this because I understand this, they step in 3 years down the line and they think, well, hang on a minute, the add backs you're talking about are perhaps not equal to the cost bill now. And so they're sort of saying, oh gosh, I can't see how all of this has happened. Whereas if you follow it all of the way through, when you started the case 3 years ago, those add backs looked egregious. It looked very clear that somebody was going to say that needs to be put in. But once you had 25 applications, they've gone as a litigant in person to 3 of them. You can't get the disclosure, all of those sorts of things. Then suddenly, the judge just thinks, oh, you're all as bad as each other because you've racked up this cost bill. And that is the difficulty, is suddenly it makes it appear like everyone's as bad as each other when that is not the reality of the situation.
That's part of the problem, isn't it? It's the system seems to benefit the perpetrator more than the victim consistently. I'd like to thank my guests today, Olivia Piercy, Anita Mehta and Samantha Hillas KC, for their enthusiastic and enlightening discussion about conduct and financial remedy proceedings. My next podcast will be on post-separation abuse with Professor Catherine Spearman from the Pennsylvania State University. So please follow Control and the Law for that episode.